Good afternoon, Judge Cavender.
Good afternoon.
Your Honor, this is Envistacom, LLC on the motion for entry of an order converting the involuntary case to a Chapter 7 pursuant to USC Section 706A.
All right, thank you very much. And thank you to all the parties for your availability to be on a call on such short notice. I have reviewed the motion for entry of an order converting the involuntary case to a case under Chapter 11 under Section 706 of the Bankruptcy Code. My view of that motion is that, given the debtor's automatic right to convert the case, that the court could enter an order converting the case without notice and opportunity for hearing. I did, though, before entering any kind of order on the motion, want to raise a question first with Mr. Simon relative to the proposed order on the motion. Among other things, the proposed order has a specific provision which makes the entry of the relief effective, entry of the order for relief effective as of the date the involuntary petition is filed, which I view as inconsistent with Section 348 and other provisions of the Bankruptcy Code. And so I wanted to first ask Mr. Simon his views on that specific language, and then hear from any other parties with respect to any issues they have with the motion. So, Mr. Simon, I'm going to hear from you first.
Sure. Thank you, Your Honor. And again, Dan Simon on behalf of Envistacom. Thank you for hearing us so quickly after we filed this motion. I guess what I would say is we have been in dialogue with all of the various stakeholders, including Mr. Levin's client, and the procedural, procedural stature was a little bit unorthodox as we filed this motion. And we considered just filing a voluntary petition, on its own in the case. But in discussions with Mr. Levin, we were concerned that necessarily would mean that the petition date would be on that date. And we are trying to preserve value for unsecured creditors. And one of the concerns for Mr. Levin that, we don't take lightly is, chopping off another, call it 50 days from a look-back period. And that was our purpose in including number 3 and kind of doing it in the way that we did rather than simply filing a petition. But obviously, to the extent Your Honor believes that's inappropriate or not consistent with 340, then obviously that doesn't change our view of converting, and we would not be opposed to entering that order without that provision.
Is there, based on a limited amount of time searching, I didn't see any authority for doing what you're asking the court to do. Do you have any authority? Have you seen this done in any other case?
I don't have any on hand, though. I don't, Your Honor.
All right. All right, I'll hear from other parties. First, I'll hear from Mr. Levin.
Thank you, Your Honor. I was trying to get off mute. I apologize for that. So we have the same concern the court has, I think. We are unclear as to, let me just state as a practical matter, I don't know that I care that much, but from a strict statutory interpretation standpoint, I do have some concerns that I don't know what authority the court has to, in essence, non-pro-tonque an order for relief back to March 21. That strikes me as a little bit unusual. And I did, like the court did and Mr. Simon did, I did a quick spin through the code in some case, see if there's any cases and addresses, and I couldn't find anything, in the 20 minutes I looked. But it did seem to me that one way to skin this cat, if you will, is to, and what I thought would be appropriate would be for the debtor to withdraw the motion to dismiss, consent to the relief in the involuntary case, and then have the court enter an order converting the case to one under Chapter 11. And obviously the debtor has the right to do that, as the court noted. I think that would be a more straightforward way of handling this. Just in looking at the statute, the Section 303 of the Code suggests that the court should enter an order for relief in that case. I don't know how it enters an order for relief in another under another chapter, because the Code specifically says under order for relief under the chapter under which the petition was filed. So that's, I think, maybe a better way to go about it. But as I said, as a practical matter, we're somewhat indifferent. We're fine with the case being converted to a voluntary 11. And our main concern, as Mr. Simon noted, was making sure the petition date didn't change from March 21.
All right. Thank you very much. Let me hear next from Mr. Roberts with Action Capital Corporation.
Good afternoon, Your Honor. Matt Roberts on behalf of Action Capital Corporation. Your Honor, my clients don't have really kind of much of an interest in this notion. We support it, but other than that, we're basically paying off at this point, and I don't really have any view on the matter.
All right. Thank you, Mr. Roberts. I'll hear next from Ms. Champion or Mr. Wolfson on behalf of Northern Trust Bank.
Your Honor, they have not joined the call as of yet.
All right. I'll hear next from Mr. Sewell.
Your Honor, Henry Sewell for Atlantic Dive Supply ADS. Mr. Brogan is on the phone with me as well. We support the conversion of the case to Chapter 11, so we do not oppose that. I agree with Your Honor's statements that I don't think there's any authority for what the debtor has proposed with respect to timing. But again, we do not oppose the relief being granted in that sense.
Thank you, Mr. Sewell. I'll hear next from Ms. McDonald.
Thank you, Your Honor. Jenna McDonald on behalf of Alan and Elisa Carson. We don't particularly have a position on the motion either. We don't oppose it.
All right. Thank you very much. I think there was a Ms. Brown.
Yes, Your Honor. Heather Brown, who represents Lynchpin Solution. Ms. Brown? You have to unmute yourself.
Ms. Brown, you may have to hit star 6 to unmute yourself.
I hit star 6, Your Honor, but I didn't realize I had muted it on my phone, so my apologies.
I can hear you now fine. Thank you very much.
We do not oppose a conversion. I've been listening to the issues relating to the petition date, and, just from what I've heard, I think, I would agree with some of Mr. Levin's comments regarding 303, that we have no opposition to the relief. It would just be a question of the dates being in accordance with the code.
All right. Thank you very much. Your Honor, I'll hear next. Who's speaking?
Sorry, Your Honor, this is Mr. Wolfson on behalf of the Northern Trust Company. I was having trouble logging in or unmuting.
All right. Have you been able to hear what transpired so far, Mr. Wolfson?
Yes, Your Honor. Again, I'm at the Northern Trust Company, and just want to, for the record, that we don't take a position with respect to the issue before the court.
All right. Thank you very much. I'll hear next from Ms. Colba, the United States Trustee.
Good afternoon, Your Honor. Lindsay Colba on behalf of the United States Trustee. I would agree with the court. I don't believe that the petition date would change. As often is the case with involuntary petitions. The petition date and the date of the order for relief would not be the same, but I do believe that the date of the order for relief would be the date that the court enters the order. The United States trustee is prepared if the court enters the order for relief and converts the case, grants the debtor's request to convert the case to Chapter 11. The United States trustee will immediately proceed with her duties in terms of soliciting a committee of official committee of unsecured creditors and scheduling the meeting of creditors in this case and appointing a committee if a sufficient number of parties are interested and deemed eligible by the United States trustee.
All right. Thank you very much, Ms. Colbert. Any other creditor or party in interest wish to be heard? All right, Mr. Simon, in light of Mr. Levin's comments, do you have any other suggested route for resolution of the issue?
No, Your Honor, we're fine with your, we're fine with your suggestion as to not change the petition date. I think that makes sense to us. Just one procedural or housekeeping note. We do believe that the case meets the complex case procedures set forth in this district. We didn't want to go ahead and file that until the order for relief was entered, but we will proceed to file that subsequent to the entry of the order.
Okay. Bear with me one second. So, as I understand, Mr. Simon, your position is you're okay with the order for relief being effective as of the entry of the order, not as of March 21st?
Yeah, I didn't, just to be clear, I didn't believe that Mr. Levin's suggestion necessarily fixed that, but if I misheard him or misunderstood that, I'm happy to, have a dialogue with Mr. Levin if Your Honor thinks that's appropriate.
I'm more than happy for you to have a dialogue with Mr. Levin. I just want to make sure that the order gets entered as promptly as possible, whether that's today or tomorrow. The order for relief is going to be effective when I enter the order. The petition date's not going to change. So if there's something about what Mr. Levin suggested, and I'm not sure I completely understood what he was suggesting, if there's something about the way Mr. Levin suggested that provides any specific relief different than what your order provides, other than the language about it being effective March 21, then I'm happy for the parties to talk about it.
Yeah, I didn't hear anything from Mr. Levin that necessarily changed that issue. So as I noted at the outset, we're happy to have the court enter the order, effective as of the date that the order is entered.
All right.
Your Honor,
Mr. Levin, anything else you?
Yeah, I'm sorry if I was confusing people. And so let me just restate. I think we are in accord, Your Honor, that the order for relief would be effective the day the order is entered, whether it's today or tomorrow, whenever that would be. And then the court, I would envision, would enter a second order converting the case to one under Chapter 11. And that, to me, seemed to be the cleanest way to do this. So if I said anything that caused people to think I was saying something different, then I apologize. But that's kind of what we have in mind.
I'm looking at the specific order. Wait 1 second. I'll have all the parties.
Your Honor, this is Lindsay Colwell on behalf of the United States trustee. I do agree with Mr. Levin that it may be best to have two separate orders, a clean order for relief and then a subsequent order granting the debtor's request to convert the case to Chapter 11.
Bear with me 1 minute. I'm looking at the proposed order that's attached to the motion, which is so your suggestion, Ms. Colbo, would be to make the second paragraph of the order a separate order after
Your Honor, I'm looking at the order. Like I said, I feel like there can be just a standalone order that is an order, like the order for relief, and then there would be a subsequent order that would be granting the debtor's motion to convert the case to Chapter 11.
I'm fine with one order or two. Mr. Simon, do you want to prepare two orders, or do you want to, do you prefer still it to be one order?
We view it as a distinction without a difference. Paragraph 3 states, this order shall constitute an order for relief with respect to the involuntary case pursuant to 11 U.S.C. Section 348A. I think Your Honor is suggesting we simply strike the remainder of that sentence that says as of March 21st, 2023. I think if you do that, I think we capture, and maybe we reorder 3 and 2 so that it's an order for relief and then it's converted. We're happy to do that. If Your Honor prefers that we do it in 2 orders, we're happy to do that. I struggle to see the procedural difference, but we're happy to conform to Your Honor's preference on this.
I really don't see a big difference. I do think that paragraph 3 should come before paragraph 2 without the as of March 21st language.
Yes, we're happy to take care of that.
Mr. Levin, is there any strong reason why it shouldn't be in one order versus 2?
No, Your Honor. I think with Your Honor's suggestions as to the restructuring of the order and the striking of the as of March 21st, I think we're fine with it being a single order. I also would not have a problem with it being 2 separate orders, but as I said at the outset, I don't care all that much in that regard.
All right, thank you. Ms. Colville?
The United States trustee would have no problem with it being in one order.
All right, thank you. Any other creditor or party interest wish to be heard? All right. Mr. Steinman, with respect to the request for consideration of complex procedures, do you anticipate that your request will include a request that be assigned to one of the judges on the complex panel?
Well, that was one of my concerns, Your Honor. We understand that you are on that panel, but not until, I believe, August 1st.
That's right.
History, we would prefer to stay with Your Honor. So we would seek to keep it in the same court that it's been in, but please let us know if that's not workable given the procedures.
I think it's workable. You should just make that request in whatever you got.
We will, Your Honor.
All right. Any other issue we need to take up today?
No, the only other thing I would say, Your Honor, we note this in our papers and just wanted to clarify while we have everyone on the phone. We do intend to, I certainly intend to come in person on the 17th. We're working with Northern Trust on a cash collateral order. We may have just, very limited, I'll call them first days, but not the traditional first days that you would normally see, that we would seek to have heard on that date. And we assumed that given that you had that calendared out for the motion to dismiss, that hopefully that time is still available and that we can address the court at that time.
That time is available and would be an appropriate time to consider an initial request for cash collateral and any other potential first day issues.
Thank you, Your Honor.
All right. Any other issue we need to take up from any other party? thank you all again for being available on such short notice.
Okay. Thank you. Have a good afternoon.
Thank you, Your Honor.